On fait 45 minutes chacun, donc après on fait un peu de débat. Ça fait jusqu'à 6 heures, on peut faire 6 heures. Ok. Ok. Si tu me permets, tu me sais ici parce que s'il y a des personnes qui.
Pour changer les diapos, je te fais signe.
Oh, tu m'indiques que tu prends ça. C'est comme ça. Tu m'indiques. Tu m'indiques, c'est bien. Comme ça, on va faire.
C'est bon. Je note.
Comme ça.
Pardon.
Ok. Ça restera. Je vais
Great.
Okay.
Good afternoon to all of you. Thank you very much for inviting me. I would like to thank you, the Professor Marc Campins, for inviting me in the context of the chair, the European chair, Jean Monnet, to present my researches concerning the participation of European citizens at the European level, I mean, for the implementation and the design of law, environmental law. I sent you some documents.
Yes,
Maybe
I actually sent to the participants, to the attendants, one of the two documents, the one of the tube.
Okay. Okay, so I'm not going to enter in the details of this document. It was just to inform you about what I'm going to talk. So I'm just going to make my presentation, but if you are questioned about this document or my presentation, don't hesitate at the end. So the principle of public participation enables the public to be heard and to affect decisions. It's the objective. And one of the first international instruments that proclaimed this principle was the UN World Charter for Nature, that you can see on the screen, which was adopted by the UN General Assembly in 1982. And the paragraph 23 of this charter is very important because that document states that all persons, in accordance with their national legislation, shall have the opportunity to participate individually or with others in the formulation of decisions of direct concern to the environment, and shall have access to means of redress when their environment has suffered damage or degradation. This is the beginning of the participatory principle. Maybe I can share you the PowerPoint later.
Yeah, sure.
Not to oblige the, yes, it's not necessary to write what you can see on the screen. You will have the PowerPoint later. After this UN World Charter for Nature, so next slide, thanks. Adopted 10 years later, the Rio Declaration on Environment and Development describes the principle of public participation as follows. In Principle 10, you can see environmental issues are best handled with participation of all concerned citizens at the relevant level. At the national level, each individual shall have appropriate access to information concerning the environment that is held by public authorities, including information on hazardous material and activities in their community, and the opportunity to participate in decision-making processes. The principle is very complete. States should facilitate and encourage public awareness and participation by making information widely available. So effective access to judicial and administrative proceeding, including redress and remedy, shall be provided. This principle, the principle 10 of the Rio Declaration, is the basis for all declaration, instrument, legal texts dealing with the participatory principle. Recently, I am not going to enter into details of this agreement, but the Paris Agreement, a very recent agreement taken under the United Nations Framework Convention on Climate Change, also contains provisions on public participation, but dedicated to climate change. Its preamble mentions the importance of public participation and public access to information to the climate change issues covered by the agreement. So years after years, you can see some different convention that deals with information or participation to the citizens to decision-making process. What about the regional level? I start about the international level, then regional level. I'm not going to mention and to give you all the legal text that deals with this matter, but just focus on the main importance. So what about the regional level? There is the Convention on Environmental Impact Assessment in a transboundary context. It is called the ESPOO Convention, taken in 1991. It was taken 1 year before the Rio Declaration, but you can find in this convention some aspects of the information and public participation. In this convention, state parties should facilitate public participation within the environmental impact assessment procedure. So it was only an aspect of public participation, the environmental impact assessment procedure, but this aspect includes and aims at encouraging the public participation. There is another convention, the Convention on Access to Information, Public Participation in Decision-Making and Access to Justice in Environmental Matters. It's a very long title, but you can remember this convention under the Aarhus Convention, the very known Aarhus Convention, taken in 1998. It is the only agreement, the only environmental agreement that is completely dedicated to public participation. The Aarhus Convention is based on the principle of public participation as described in Principle 10 of the Rio Declaration. So if you had just one convention to remember concerning the public participation in environmental matters, remember the Aarhus Convention in 1998. What about the European level now? At European level, there are a lot of directive and regulation concerning the information and participation of citizens to decision-making process, but I'm going to mention, to quote two directives, two texts, two important texts. The first one is the Council Directive of the 7th of June, 1990, on the freedom of access to information on the environment. You have the reference, no, you have the reference on the screen. I'm not going into details of this directive, but I would like to mention some main articles. The Article 1, for instance, describes the object of this directive. And the object of this directive is to ensure freedom of access and dissemination of information on the environment held by public authorities, and to set out the basic terms and conditions on which such information should be made available. So this directive is dedicated to obligation toward public authority. The Article 2 of this directive concerns not the object, but the purpose of this directive. There are three main purposes identified. First, the first purpose is that information relating to environment shall mean any available information in written, visual, oral, or database form on the state of water, air, soil, fauna, flora, land, natural site, activities, and so on. So this article describes firstly the field of application. And you can see that it is a very broad field application concerning the nature and the form of the information. It can be written, visual, oral, database, and so on. And the topic which on the information is applied. It can concern water, soil, air, fauna, flora, land, natural matters, activities, and so on. The second purpose given by the article is that public authorities shall mean any public administration at national, regional, or local level responsibilities and possessing information relating to environment with the exception of bodies acting in a judicial or legislative capacity. So that means that at national level, the information given by public authority concern any part of the different region of the country. It is information given at national level, but at subnational level, for instance, by municipalities. And if member states doesn't provide information, there is a possible issue for citizens, and the possibility for a person who considers that his request to information has been unreasonably refused or ignored, or has been inadequately answered by a public authority, may seek a judicial or administrative review of the decision in accordance with the relevant national legal system. So there is an option, a possibility, a capacity for citizens to ask for the information that the public authorities doesn't want to give. The second European instrument important is a directive of the 26th of May 2003 of the European Parliament, providing for public participation in respect of the drawing up of certain plans and programs relating to the environment. So as the previous directive, I'm not going into details of each article of this directive, but just give main information. I would like to share with you the objective of this directive. The objective of this directive is to contribute to the implementation of the obligations arising under the Aarhus Convention, in particular by providing for public participation in respect of the drawing up of certain plans and programs related to the environment, and improving the public participation and providing for provisions on access to justice. So this directive was a kind of transposition of the Aarhus Convention at European level. So this is another important European legal text dealing with the participatory principle. Closely connected to human rights, the right to health, the right to private life, the right to culture, and so on, there are three different elements. There are three key ideas of participatory principle. The first ideas, and you have them on the screen, is the participation in decision-making process dealing with environmental issues. The second key idea is the access to environmental information. And the third key is the access to administrative and judicial proceedings. We can consider them as the three pillars of environmental democracy. Citizens have right to have information. They have right to participate to decision-making process concerning environmental matters. And if they can't have this information, or if they can't participate to the decision-making process, they can go under the juridical or administrative authority. So what does public participation include? I said there are three key ideas, and this is the three elements of public participation. Participation first in decision-making processes on environmental issues. This means that public participation enables authorities to take into consideration the public environmental concern. This leads to the accountability and transparency of decision-making on environmental issues. And this element implies that individuals, groups, and organizations have the opportunity to share their views and interests in the making of decisions that have or may have an impact on the environment. Such decisions include the drafting of regulation, the enforcement of such regulation, and environmental impact assessment. And it includes participation in decision-making on local, national, and European policies, strategies, plans, and both on long-term and short-term projects. So there are a very broad acception and approach concerning the participatory process. If you read the different documents I said you, or at least one of them, you could find that the issues of participation is transparency, is the inclusiveness of citizens into decision-making process and so on, and the accountability of decision-making. It's a kind of new way of governance. The second key, the second element is the access to environmental information. This aspect consists of two elements. The first one is the availability of information about the environment, and the second one is the mechanism of public authorities to provide information. So there are two aspects here: the information, the concrete possibility to transmit and to share the information, and the way for sharing the information. What kind of process the public authority is going to put on to share the information with the citizen. The third and last element is the access to judicial and administrative proceedings. This enables individuals who suffer damages from environmental harm to initiate actions before the appropriate administrative and judicial authorities to obtain a form of prompt and adequate compensation. So what about now the implementation of participatory principle? More precisely, what is the participation in decision-making process at European level? I'm going to focus on this aspect for the next minutes. What are the different tools? What are the different ways for acting? You can find at European level different tools and different possibilities to contribute to the decision-making process or to the implementation of environmental regulation. The first way is through the European Ombudsman. Do you know the European Ombudsman? Do you hear from? Yes? Okay. And do you know his name or her name? No, I'm going to give you the name. The European Ombudsman is an independent and impartial body that holds the EU's institutions and agencies to account and promotes good administration. The Ombudsman helps people, businesses, and organizations facing problems with the EU administration by investigating complaints about maladministration by EU institutions and bodies, but also by proactively looking into broader systemic issues. I'm going to give you two examples of the action concretely of the Ombudsman. And the Ombudsman, it's not a good term actually, because the actual Ombudswoman is Emily O'Reilly. So it's a woman, and the Europe keep the original name of Ombudsman. So the first example is an inquiry concerning the lack of transparency in the EU decision-making process. More precisely, concerning the process on fisheries, the fishery matter. And the second example I am going to give you concerns the Commission refusal to give the public access to documents concerning the positions taken by national authorities on the risk of pesticides to bees. So a first matter concerns the fisheries, and a second matter concerns the pesticides and the effects of the pesticides on bees. First, the Ombudsman, for the first inquiry, the Ombudsman launched an inquiry following the first request. Especially, the Council was criticized for the way in which it adopted the annual regulation fixing the total allowable catch of fish stock in the North Atlantic for the 2017 year. The Council, so the European Council, okay, was criticized for, first, failing to record the positions expressed by member states during working groups. So the Council didn't collected good information during the discussion meeting. Second, the Council failing to provide European citizens with rapid access to legislative documents. So the Council didn't share the information enough fast. And third point, the Council have an incomplete and not very user-friendly register of the document. So that means that the interface, the platform for sharing information is not user-friendly. The Ombudsman in this context make the inquiry and ask to different persons, different citizens, the Council to explain its position. And finally, he granted the request for clarity and availability of information. So the Ombudsman decided that the Council not applied effectively the participatory principle. The second inquiry concerned the European Commission's refusal to grant access to correspondence and documents related to the discussion in the Standing Committee of Plant, Animal, Food and Seeds. Just remember the discussion in the European Food Safety Authority. And the Commission didn't share the guidance document on the risk assessment of plant protection product on bees. The European Commission had refused access on the grounds that disclosure of the member states' position would jeopardize the decision-making process underway in the Standing Committee. So the Ombudsman launched an inquiry, and at the end of the inquiry, she found that the documents in question should benefit from the regime applicable to legislative documents under European law on public access to documents. So the Ombudsman also considered that the document contained environmental information and that public access to these information was in line with the requirement of the Aarhus Convention. So on the basis of these remarks, Émilie Oreiller, the Ombudsman, recommended that the Commission grant the public access to the requested document. There is another way for citizens to participate to a decision-making process. It is a European Commission public consultation. It is a second opportunity. In this context of a public consultation, citizens and businesses can share their views on the new European policies and existing laws. But it's a process of consultation. I'm going to give you two examples of consultation to be more practical. First example, the public consultation on eco-design, energy labeling of refrigerators, dishwasher, washing machine, televisions, computers, and lamps. And this consultation, which is an official consultation with this official title, this consultation is based on the Commission's observation that the majority of European citizens are likely to buy these products at least once in their lifetime. So the aim of this public consultation is to gather their views in a transparent way with a view to developing specific regulation for each product group. This means that the Commission needs position and advices and remarks from citizens, but from the private sectors too, to better make or modify the regulation. The second consultation, example of consultation, is the consultation on a European initiative on pollinators. This consultation aimed to gather views on the decline of pollinators in order to develop a European initiative specifically for them. The consultation focused on the causes and consequences of the decline and possible mitigation measures and the European dimension of the problem. So you can see that sometimes the consultation aim at modifying regulation, existing modifying, and sometimes the regulation, the consultations, aims at creating new regulation. What about the European Citizen Initiative? That is the third tool for citizens to participate to decision-making process. The European Citizen Initiative was introduced by the Lisbon Treaty in 2009. But the regulation, the design, the frame of the ECI, the European Citizen Initiative, was the regulation of February 2011, and then the reform, the regulation of April 2019. Okay, so the main text is the regulation of 2011, and the reform or complete is the one of the 2019. What is exactly the European Citizen Initiative? Legally, the European Citizens Initiative represents an enrichment of the rights previously granted to European citizens by the treaties of Maastricht. I'm not going into detail of this treaty in 1992, treaties of Amsterdam in 1999, and Nice in 2003. The ECI has come to support and develop the spontaneous actions of citizens in the European Union. Considered as a pre-legislative right to initiate European legislation, the ECI was originally envisaged as a tool for participatory democracy, federating European citizens. Legally, it is foreseen that a European Citizen Initiative allows 1 million European citizens from at least 7 EU member states and of voting age in the Parliament, the European Parliament election is the necessary condition, to invite the European Commission to propose legislative measures. So what is the detailed process of this citizen initiative? First, there is a setting a group of organizers. So a group of organizers is going together to compose of at least 7 EU citizens living in 7 different EU countries. So a group of 7 organizers who come from different countries. The group of organizers is going to provide a description of the initiative in one of the official European language, and if criteria are to be met, the Commission registers the initiative. The third step is that the group of organizers is going to get the support of at least 1 million people with minimum numbers in at least 7 European countries. And to get the support, the group of organizers has 1 year. If the group of organizers collects the 1 million signature, the authorities then have 3 months to verify. So the European authorities have 3 months to verify which statements of support are valid. And if everything is okay, if all criteria are met, the authorities give a certificate. This certificate enables the group of organizers to submit the initiative to the Commission in a formal way. And then the Commission is going to read carefully the initiative, the content, and so on. And there are some steps before the final decision of the Commission. First, there are meetings with representatives of the Commission to explain the issue raised in the initiative in detail. Then the group of organizers is going to make a presentation on the initiative at a public hearing, but at the European Parliament. So first Commission, then European Parliament. And then the Commission will spell out what action it will propose in response to the initiative and its reason for taking or not taking action. This is the final decision is taken, of course, by the Commission, which is designed. Just a few words about the design of a European Citizen Initiative. Yes. When the group of organizers is going to present a European Citizen Initiative, the initiative should contain a proposal topic, so the context of the initiative, then the requirements, I mean, what does citizens want through this initiative? Third, environmental issues, benefits for the initiative, cross-cutting issues, and so on. So all the social, cultural, economics impacts of this initiative. First point, the EU treaty and legislation. I mean, on which kind of legal instrument this initiative is based. 5, the board of organizer is going to present himself or themselves. And 6, which is a possibility, the group of organizer can propose formally a legal proposition with some articles and written in a very legal way, or in a very, yes, in a legal way, to propose an official text or legal text. So I would like to just present you the diversity of the European Citizen Initiative proposition. You can next, yes. Because I don't have a lot of time, I'm just going to mention some different European Citizen Initiative which were presented to the Commission, and I just want to finish by the one of the one which has a successful story. So you have different initiatives. The first one I would like to share with you is the initiative Save the Bees and the Farmer, that asked to the Commission to support an agricultural model allowing farmers to switch to a model based on agroecology principle. Another ECI called Stop Fining highlights the existence of a trade in fins, so the shark fins in the EU, including the import, export, and transits of fins that are not naturally attached to the animal's body. So the first ECI asked for a new regulation, including the agroecology principle and so on. And the second ECI asked for modifying actual regulation to a more strict regulation. There are others ECIs dealing with climate change. You have action on the climate emergency, a quick and effective solution to tackle climate change. It is the title, the exact title of the initiative, a carbon price to tackle climate change, ending Europe's tax exemption, and so on and so on. So a lot of European Citizen Initiative and recent European Citizen Initiative deals with climate change. If I can give you one successful story for a European Citizen Initiative, it is the European Citizen Initiative Right to Water. Next. The initiative Right to Water led to a revision of the Drinking Water Directive. But as you can see, it was a very long process because the initiative was presented in 2013 and finally give a success in 2020 in the new directive of the European Parliament on December 2020 on the quality of water intending for human consumption. So more than 5 years between the ECI presentation and the concrete action of the Commission. What can I say about this ECI? The ECI originally asked the European Commission to propose legislation making the right to water and sanitation a human right, but also to promote the provision of water and sanitation as essential public services for all. So the European Economic and Social Committee first supported the request, and the European Parliament, considering the right to water as universal and fundamental. In the light of these elements, the Commission committed itself to take concrete measures and plan a number of actions in the line with the objectives of the initiative. And so finally, the revised directive on drinking water was adopted by the European Parliament on the 16th of December 2020. So although the Parliament based its revision on a working document issued by the Commission and by the ECI, the Commission, it was a public consultation, as we saw before, a public consultation of the quality of drinking water that was launched in 2014. So the Parliament based his decision, his work, on this consultation made by the Commission and the European Citizen Initiative. Right to water remains the societal trigger for this reform. The directive, which entered into force in 2021, the difference between the elaboration and the entering into force, contributes to achieving Sustainable Development Goal 6, called Clean Water and Sanitation. And within this overall framework, the directive calls for several issues. First, the establishment of stricter water quality standards than those recommended by the World Health Organization, so a more strict regulation and standards. Second, the directive calls for the fight against emerging pollutants and against microplastic. Third point, the directive calls for the adoption of a preventive approach favoring actions to reduce pollution at source by introducing a risk-based approach. Fourth, the directive calls for measures to ensure better access to water, in particular for vulnerable and marginalized groups. I have 5 minutes more or not? Tell me.
5 minutes.
5 minutes, okay. So this is a very practical approach, but this practical approach have some impacts into the theoretical approach and the theoretical approach of law and the democracy principle and other notions and concepts. So if I can conclude on this aspect, the next one, thank you. The notion of citizenship through the ECI, okay, is considered in the line with the changing legal and social political landscape with regard to the notion of public participation. A strong link is made with the dimension of multi-level governance. The citizen acts locally, but is aware that his or her action has an echo at European level, as the citizens of each member state are identically concerned by the same issues and problems. In the ECI, the group of organizers refers precisely to a transnational dimensions. It does seem that we are witnessing an evolution of the notion of European citizenship. For a long time, the citizenship was understood through political rights and in reference to Maastricht Treaty in 1992. But now there is an evolution of the citizenship concern and notion. If I can have just a question to conclude on this aspect, we can wonder this one. The exercise of the European Citizen Initiative allows for the establishment of discussion groups between citizens, which enables them to assert their existence as, so this is my question, what do you think is a better expression? A group of European citizens, a transnational group of citizens, or a group of transnational citizens. Which term will be more appropriate for European Citizen Initiative? This implicitly raises the question of the purpose of an individual citizen's involvement in a ECI. Therefore, by participating in or initiating on ECI, does the citizen intend to join a group? So the first hypothesis. Does it intend to link up with a group of citizens whose issue or question has a transnational nature? Hypothesis 2. Or does it intend to link up with a group formed by citizens who no longer consider themselves necessarily linked to a territory, but to transnational issues? I don't know if there is an answer to this question, but this is a question of the best expression we can use in the context of the European Citizen Initiative. Thank you very much.
Thank you. Thank you very much for such a nice presentation. And now it's time for questions or comments. So you have the floor. So you can also ask in Spanish and French,
Yes.
because she speaks Spanish and French too. So if you are feeling more comfortable. So,
Yeah.
please.
As you
Well,
want.
maybe just for, I don't know, for people who is, I'm not even sure that this is working actually, but I don't know. Yeah.
I think yeah, on the left, yes, here.
I'm not sure. Okay, so you're supposed to be here. So please, yes, to be sure that.
First of all, thank you for your explanation. But always that I listen things about European Union, I'm really concerned that this has a lot of implications. But when I see this kind of pressure professors, and when you have to do a lot of the steps right to this new directive, for example, in the ECI, I think to myself, maybe this is no es contrario. It is opposite to the participation, because if you have to do a lot of steps, you need a lot of firms, a lot of people that has to be of all the states. This doesn't make the opposite think of participation, because when I think about it, I think, oh my God, maybe I can't accomplish this because I need a lot of people, a lot of years to make it happen. And maybe I prefer work for me for work to wait to my home and do nothing, because maybe it's very difficult. I don't know how to say it.
I'm not sure that it's your question is to know if it's really contrary to participate at European level if you have too many citizens from different culture and different. No.
What I mean is that, for example, if to arrive to this level of participation,
Yeah.
there is the principle of participation.
Yes.
But to arrive there, you have to have a lot of steps, and again with a lot of people, a lot of time, and maybe this is not an easy way to participate.
Okay.
Because you have a
Yeah.
lot of.
Yeah. And this was a problem, the original problem of the European Citizen Initiative. There was problems for translation, problems for timing to collect the 1 million signs, and there are some different positions. Before the reform, it was effectively very difficult for people, for group of organizers to participate and to submit a European Citizen Initiative for several reasons. Now, with the reform, the process is more simple, and we can observe a raising concerning the number of the European Citizen Initiative, a raising in the different ECI proposed and submitting. So I think if it was difficult to submit an ECI before the reform, since 2019, so since now, it is easier, and the different citizens from different parts of the EU has taken into account all the obstacles, and now they are more able to propose and to present a European Citizen Initiative. But one of the main problem is the language, because if you speak with a French, a Spanish, a Croatian, and so on, the main language should be the English finally. And all people in all countries doesn't speak English fluently. And it's the same problem for signing an ECI, because if the ECI is presented in English, you have to understand and to well understand the English to sign the proposition. So yes, there is some difficulties, but since the reform, it is easier now.
Okay, thank you.
Any other question? Martha? Oui, c'est bien, mais un peu plus haut.
Merci beaucoup pour votre présentation. Je me permets de parler en français car je suis beaucoup plus à l'aise qu'en anglais, et parce que c'est une question sur le système juridique français. Je me pose une question sur la mise en œuvre de ces principes dans le contexte des projets alimentaires territoriaux. Donc, sur la gouvernance participative, la législation alimentaire, il s'agit des projets qui sont en train de se mettre en œuvre avec la participation plein de facteurs. Mais quand on regarde bien la mise en œuvre, on se rend compte que c'est plutôt les administrations publiques qui sont en train de mettre ce projet juste avec une consultation un peu rapide. Et donc, la question est comment on peut faire? Est-ce que ces principes pourraient éventuellement alléger ou enfin, la participation n'a pas été respectée parce qu'il s'agit seulement de consultation.
Okay. I answer in English or
Yeah, better.
okay, okay. Okay. Concerning this aspect, in France, you have different kind of participation. You have the information, the consultation, the concertation, and the public debate. And each nature of kind of decision could be constructed and elaborating through one of the different kind of participatory process. And you're right, the most used participatory process is the consultation one, because when citizens participate to a consultation, they give their opinion, but the public authority is not obliged to take into account it. So can you make an action through the jurisdiction? Finally, no, because the consultation is just to give your point of view. But in several cases, so not in the alimentary way, but in some cases, when there is a consultation or a public debate, and that some issues are very important and some advices and remarks are given by civil society as organizations, associations, or citizens, and that advices are not taken into account, the judge often decided that the process wasn't respected. Okay, but when you have the consultation way, you have finally no possibility to contest the final decision. The only way you could contest it will not be on the basis of the process of participatory process, but on the impact of the decision on environmental matters. But there is a problem between these different participatory process, especially because with the consultation, the public authority can do what it wants, finally. I answered to your question, or?
Questions alimentaires sont énormément liées à l'environnement, sauf que là, on fait vraiment un impact.
Oui.
Et
Oui, in France, and I think, I don't know if it's the same in Spain, but in university, you have specialists for health and specialists for environment. And the specialist of health doesn't really work with the specialist of environmental, but the professor or the researchers in environmental matters get an interest in the link between earth and environment. But this is another problem which could have impact in the decision process, because there are not enough articulation between the different disciplines and questions to introduce them and to confront them in the decision-making process.
Okay. Any other question?
No question.
No more questions, please.
Well, thank you for your presentation. I have a question about how the European law effectively protects the participatory principle based on the case law of the European Court of Justice, that, for example, restricts the scope of application of environmental impact assessment to certain projects, only to the projects that affect physical aspects, and how the principle is protected in the European Union with all the projects that are concerned with the environment but do not affect the physical aspect of the site are not subject to this obligation or duty of the state to, in this case, allow its citizens to, in this case, participate in environmental impact assessment procedure.
So the question is the participation of the citizens into this environmental impact assessment of the recourse from the action the citizens can make at European level.
Yes, it is. Well, to rephrase my question, it is how the principle is effectively protected in the European Union if the environmental impact assessment procedure only applies to certain projects and not to all the projects that member states propose.
It depends of the impact of the project on environment. Finally, if the participatory process principle can be applied to a lot of matters in environmental way or issues, but the environmental impact assessment is a kind of participatory tool, finally, but is used and is applied only for a project which have a specific impact. I don't have in mind the different criteria and modality and condition, but it is only applied if there is a specific impact and condition of the project on environment. Is it the answer? Do I answer your question or not exactly?
Well, it answers one part of the question, but it was mostly referred to the recent case of the European Court of Justice that specifically limits the how the output or how the output protection applies to European Union law on the ability of citizens to, in this case, get involved in the assessment and the impact assessment procedure of certain projects. When member states allege that these projects are, if the environmental procedure is followed, then the projects may not comply with principle or objective. And in this case, I was wondering if that affected or did not effectively affect this right that was basically the basis of the presentation.
Yeah, I'm not a specialist of the European Court of Justice and the decision of impact assessment, the environmental impact assessment. I'm sorry, I can't give you a specific and a precise answer to your question today. I'm really sorry, but if you let me your email, I could take time to better think about it and to give you a complete answer. Sorry.
So, any other questions? No more questions? I actually have a question, which is just curiosity.
Yeah.
Which is, of course, you just could mention one happy story.
Yeah.
on the European initiative. So the general idea is that the European Commission is quite reluctant and that there is no consequences on whether. So I just wanted to ask you, how do you feel about that situation? Yes, of course, this is a tool that it's put there for the citizens, but in practical terms, is that difficult, as it was already mentioned, that, yeah, very few times it works. And then, yeah, individuals cannot just go before the European Court of Justice, because finally the European Court of Justice will say that they are not individually concerned, directly concerned, whatever. I mean, what is your feeling about the effectiveness of such a mechanism?
I'm not sure that this mechanism will be really useful to modify the regulation, the European regulation, or to create new regulation, but this could help and encourage citizens, European citizens, or citizens across Europe, to mutualize, to get together, to maybe create new movements, new ideas, and maybe that could lead to the creation of association, collective position. And I think the European Citizen Initiative is more useful in this way. So just to reveal, also to reveal at European level that different issues, different problems, different things are taken into account by different citizens in different countries. It's a kind of revelator of for the environmental matters, and maybe I think this could have impact at not at European level, but at national level.
Yeah.
When you have a lot of signs that come from Spain or that come from Italy, the national governments know that. The national government knows, yes, that a lot of persons within its own countries have signed the document, and so is interest in this question. And so this could have some impact at national level. But European level, I'm really not sure that it could be really successful on the long time.
Okay, thank you. So any other questions? Please.
Thanks a lot for your presentation. And just two questions. No? The first one is that about the initiative of right to water. No, do you know the opinion of people who propose this initiative? Because the name is right to water, and in this directive there is any there is not any right there, no, to water.
Yeah.
No, and this happened. It used to happen sometimes. No, the big difference between the proposal and the text. No? And the second one is, what is your opinion about the role of citizens to implement environmental European law? No, in the case of the infringement procedure, no, as just a complaint.
For the first question, the group of organizers was finally very pleased and happy because the Commission has taken into account his European Citizen Initiative. Finally, it was the conclusion of the group of organizers. Okay, there is no rights officially. There is no rights in the directive of 2021 for 2020. But there is a consideration. The Commission considers the European Citizen Initiative submitted in the new directive. So finally, I don't know if it's just to have a good face and to say we proposed a European Citizen Initiative, and finally, look, there is a new directive and there is a kind of inspiration, influence, and so on. I don't know if it's just for the good way, or we proposed and the Commission executed in one way, or if they are very disappointed. They didn't reveal, the group of organizers never accept or never said that they were disappointed of the directive. So I think it's a kind of mixed position, but even if they were disappointed, I think they didn't say that, and they didn't accept that in the different in front of the different population of the Europe. And for the second question, it was concerning the
citizens in the implementation. No?
Yeah. So at European level, we know I didn't discuss about and I didn't talk about this aspect, because you know that, as you said, the citizen can't make a complaint in front of the European Court of Justice easily. In my presentation, I had a slide on two cases, the Pomade case and the Shifting Greenpeace case, concerning the right to access finally to justice if you are a citizen and if you are a group of citizens, and to prove that you suffer from damages for environment and so on. And finally, the European Court of Justice refused to admit that the citizen could make a complaint for the infringement of the participatory process. And I didn't say that, but the general advocate in the context of the process said that finally, if the European Court of Justice admitted this capacity for individuals, it was against, it will be, it should be against the treaty, the European treaty. So it is not possible to make a complaint finally, even if it is a participatory principle, which is contained in the European legal text.
Okay, so is there any other question? No more questions? Okay, then if it's not, I would like to thank you very much
Thank you,
again, Professor Pomade, for your presentation and answering our questions here. And I would like also to thank our attendants. And if I may just remind you that there is a list somewhere here. And yeah, I really need that those who are here, you sign the list, please. So if there is no more question, just saying thank you very much again. And that's all. Okay.
Thank you.
Okay. Thank you.
Thank you very much.
Okay.